Executor duties and common mistakes during probate in California. That's our topic. Let's get started. When involved in a probate, there are a lot of people involved. Probate judges, probate attorneys, the probate referee, and the beneficiaries. So let's talk about the 12 common mistakes executors make. But before that, I'm KimWard. I am a certified probate real estate advisor and an expert at helping with homes in probate here in San Diego, California. Number 1, executor delay. Obviously, you don't need to start the probate process immediately once someone passes away. But waiting too long after your loved one passes, well, that can lead to problems later. Of course, it's certainly okay to grieve, but making sure that you get things started in a timely manner is also important. As time goes by, taxes add up and creditors can get pushier and pushier. And the heirs, the beneficiaries, can get impatient. Executor common mistake number 2, paying probate funds out way too early. As the executor or administrator, you have the authority to approve creditor claims and actually pay those creditors. You also have the authority to distribute the assets to the beneficiaries. Sometimes, however, if the estate doesn't have sufficient funds or sufficient assets to pay all of the debts on the property or to honor all gifts that are in the will, you want to be careful about not taking care of that way too early. Now, keep in mind that when there are various things that you would be responsible to pay out, creditors do take precedence. According to the law, the assets need to be used to pay any of your loved one's creditors. If you fail to follow the law and you pay out any of the funds too early, you could be held personally liable. Executor common mistake number 3, failing to make the portability election. Unless you are an estate attorney, you probably don't even know what portability is. I'll tell you, when I first started this, I had to look it up. What it is when the first spouse dies, the executor can make this portability election. Portability allows the surviving spouse to apply for the deceased spouse unused federal gift and estate tax and the estate tax exemption to his or her own transfers during life or after death. But to secure these benefits, the executor of the deceased spouse must make the portability election during a specific time. Executor common mistake number 4, not following the terms of the will. Executor Maria shared with me that her grandmother had told her that she wanted each of her grandchildren to receive $10,000 from her estate upon her death. Of course, Maria wanted to follow what her grandmother had told her, but if Maria had paid out that $60,000 to the 6 grandchildren and had not followed the will, as you can imagine, her siblings who were in the will and were the beneficiaries of her grandmother's estate, of course, they're going to want to know what happened to that $60,000. So even when someone tells you something during their life, if it is not put into their will, in the case of a probate, or into their trust, into the case of the loved one having a living revocable trust, anyway, as the executor, you have to follow what's dictated in the will regardless of what your feelings are and what your loved one asked you to do upon their death. So in that case, the grandchildren did not receive the $10,000 that her grandmother had asked her to give to each one of the children, unfortunately. Executor common mistake number 5, failing to provide all probate asset information. One executor error that attorneys really don't like is when something is missed, when the executor comes back to the probate attorney after the probate has closed and says, oops, we found this piece of land that belonged to our loved one, or there were some stocks that we neglected to put into the probate, because then the attorney has to go back and redo things, not exactly open the probate again, but it's very costly and time consuming to go back after the probate is closed and probate other assets. So we want to be careful that we don't cause a situation where the probate attorney sort of has to open the probate again. Common executor mistakes, number 6. Executor failing to communicate. Nothing causes more problems than an executor failing to keep the beneficiaries in the loop on things, failing to communicate with them. So you want to make sure that you communicate frequently with the beneficiaries during the probate administration process. If the beneficiaries start to become anxious or suspicious, the matter can spin out of control very quickly. I have had phone calls from people that have watched my YouTube videos that were beneficiaries asking these exact type of things, that they were worried about what the executor was doing. And in those cases, I always just say, I'm not an attorney, so I recommend you first speak to the executor and see if you can feel more comfortable with what's happening. And if that's not the case, then I recommend they speak with an attorney. So taking the time to keep the beneficiaries informed all along the way can help you to avoid a lot of grief. And as a little side note, when I am helping with a home in probate, I will frequently email my client, the executor or the administrator, with what's happening with the real estate side of things. And then they can simply cut and paste that to send to all the best beneficiaries and keep them from feeling nervous about the process. Our goal is to keep the process running smoothly. Executor common mistake number 7, confusing probate assets with non-probate assets. As the executor or the administrator of an estate, one of the first things you need to do is to secure all of the loved one's assets in probate. You'll want to do this as soon as possible. Many of my clients have waited until they get appointed by the courts and they know that their letters of administration are on their way. Then they will feel comfortable to start securing things. So the difference between a probate asset and a non-probate asset is the non-probate asset is something that there's a beneficiary designated, or perhaps there was someone else's name on the deed or on the bank account. In some cases, that a probate asset will just have the loved one's name on it. So for instance, like a bank account. So once you're appointed, you'll simply need to take the documentation to the bank showing the letters of administration and the death certificate from your loved one, and you can close that account and move those funds into the estate account. In the case of real property, the home, naturally, in most cases, the home is prepared, marketed, and sold, and the proceeds from that sale, again, are put into the estate account. Those are assets that need to go through probate in most cases. Common examples of non-probate assets are trust assets, something that's held in a trust and has beneficiaries. Proceeds of a life insurance policy almost always have beneficiaries. Certain types of jointly held property, like in the case of spouses, the husband passes away, but the wife is still with us. That is something that would most likely not have to go through probate. Or funds held in a retirement account typically would have beneficiaries attached to it. Executor common mistake number 8, not collecting probate funds in an estate account. This is a big one. As an executor or administrator, your number one responsibility is to diligently take care of the assets in the estate. Make sure you keep accurate records of everything you do. So when the time comes to pay taxes, make distribution to the heirs, and submit a final accounting of the probate in California, you are fully prepared. Executor common mistake number 9, getting help from friends instead of professionals when involved in a probate in California. Probate can be a complicated and draining process, especially when you are dealing with the loss of a loved one. Trying to do everything on your own during this time of mourning is an excellent way to somewhat torture yourself and perhaps get yourself into a lot of trouble. Executor common mistake number 10, ignoring claims against the probate estate. It's very common for people to pass away and have bills, unpaid bills. If they are ignored by the executor, you, the executor, may end up being personally responsible. We don't want that. Executor common mistake number 11, Executor self-dealing. An example of self-dealing is Tom's father passed away and he had this nice BMW with a value of about $50,000. Tom was in the process of buying that BMW for $1,000. He knew his dad would like him to have the car, and it wasn't written down anywhere that his father gave him the car. So he was thinking he could just buy it for $1,000 and put that $1,000 into the estate account. That would be a case of self-dealing. Tom's sister became aware of his intention and contacted an attorney, and that stopped that whole situation. Unfortunately, Tom did not get to have the BMW. He did need to sell it, and that $50,000 was put into the estate account to be distributed equally to all of the beneficiaries. And executor common mistake number 12. Handling tangible assets under your own terms. Sandy's dad passed away and he had $100,000 in a bank account. There were 4 siblings and they were to receive 25% of any assets from the estate. But if there are furnishings and perhaps computers or just stuff in the house, it could be even family photos and sometimes perhaps expensive art, it's hard to divide those things up fully evenly like the $100,000 that each of the siblings received $25,000. But those tangible assets also must be divided up equally. Many times when I'm involved with a probate, the family works out a system to divide those items up. And in Sandy's situation, the family did work together to make it a fair situation, dividing up all of the remaining tangible assets. So that's it. Those are the 12 common mistakes that executors can make. I hope you found it of value. Please subscribe, hit the bell button and that notification. That way it tells the algorithm that you do appreciate what I'm sharing about probate real estate and all that's involved with probate. Thanks for watching. I'll see you next week.